trouble in your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time is broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. I am your host, Daniel, and today is Judge Erane C Washington, and the case is being heard in her courtroom. So let's get started. And let's go back to StreamYard, make this bigger.
Rashavia Gunn. Miss Gunn, can you state your name, please?
Rashavia Gunn here.
Thank you. All right, Ms. Gunn, I have a community corrections violation report that I need to arraign you on, okay?
Yes, ma'am.
All right, it indicates, ma'am, that you tested positive. One second, let me get this right. So it says that you didn't test between the hours of September 11th, you didn't test between the hours of 6 and 9, did not test between the hours of 9 p.m. and 12 a.m. You did test at 12:23. You didn't test between 6 a.m. and 9 a.m. on September 12th. And then on September 14th, you didn't test between the hours of 6 a.m. and 9 a.m., not testing until 12:50. And then on September 15th, you didn't test between the hours of 6 a.m. and 9 a.m., testing at 12:14.
The world's first titanium nonstick pan.
Yes,
And then
ma'am.
stopped testing as of September the 17th, apparently. You have a right to have a hearing on those violations, at which time you could be found guilty, or if you pled guilty, you could have your bond revoked. You've had a chance to talk to your attorney, and I've tried to give you several times to talk to her so we can make sure we get through this process and hopefully get on the right page about things. Ms. Muller, where you and your client at with this?
Yes, Your Honor. Thanks for the chances to speak with Ms. Gunn. After speaking this final time, I do think we're ready to move forward. Ms. Gunn understands the violations that the court just named, and she will admit to those.
Is that correct, Ms. Gunn? You're gonna waive your right to have a hearing and you're gonna admit that you violated the conditions I just indicated?
Yes, Miss Washington.
You can raise your right hand to be sworn, please, ma'am.
Right here. Yes, ma'am.
Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Great, thank you. Ma'am, you failed a test during those times and tested late at sometimes, is that correct? And then you stopped testing as of September 17th?
Yes, ma'am.
To find that there's a knowing and willing admission to the violations. Are you satisfied, Mr. Barnett?
Yes, Your Honor, thank you.
Defense is also satisfied.
All right. So what's going on with this, Ms. Mueller? Why is your client not testing?
Your Honor, Ms. Gunn, the original late tests were because she is staying at a shelter. It's just a night shelter. She has to leave every morning at a certain time. And I think it was just a matter of getting then to a new place where she could sit down and be able to blow into the machine. And Your Honor, the discontinued testing, is that on the SoberLink or for the substance
You know, it
testing?
might be the substance testing. That might be the substance testing.
She told me
Yeah.
I could wait until the 26th to test, because that's when I get paid, and then I might be able to get a ride there
On the what day, ma'am?
on the 26th.
That's Friday.
Yeah. I'm waiting on. I'm on disability, so I'm waiting on my disability to deposit, so I can be able to get a ride and everything if I can. I don't have a car, and yeah.
So she hasn't tested late since September the 15th, it appears, and she's been testing timely since then for the SoberLink.
That's how I was reading the report from corrections, Your Honor.
And her testing, her other testing wouldn't be an issue, but for the positive cocaine test at one time.
Correct.
Mr. Barnett, do you have thoughts on this?
I think you're right. I mean, the underlying case doesn't have any substance abuse issues, but she obviously tested, and we were aware that she tested that time for cocaine. I'm glad that she's continuing the SoberLink testing, even though she's been late. I know she has significant issues getting that done on time. So I would leave it to your discretion. Perhaps we remove the controlled substance testing. I'll leave it in your discretion.
I'm not gonna remove it, but I'm not going to put her in jail or anything for it yet. I know she's having some financial hardships. I'm not gonna let her test when she wants to, but this is what I'm gonna say to you, ma'am. You need to hold on to that money, and you need to call after the 26th, and they'll tell you when you need to come in to test, okay?
Yes, ma'am.
As far as the pretrial is concerned, what do we want to do with that, Ms. Mueller?
Your Honor, I would be requesting an adjournment. I didn't reach out to Mr. Barnett again about the plea offer, because I did assume that we'd probably want to see at least a couple test results for the substance results.
He's
I
not
don't know if
my,
that's the
I'm sorry. He's not my person that I talk to anymore. Her name is, I think her name is, I have a new person that I talk to. I don't talk to him anymore.
Ms. Gunn, she's talking to the prosecutor, ma'am. The prosecutor is the person who prosecutes the case. She's not talking about your reporting person, ma'am. It's a different person.
Oh, okay.
Mr. Barnett, I don't know if you're in agreement, and maybe an adjournment might be appropriate to see if we can get some more testing information before we move forward.
Yeah, I would be in agreement with that.
How long, do you want to see test results, Mr. Barnett?
If we could have at least 3 weeks, maybe.
Are we here on October 13th?
This is the best. Stainless steel. It has a very strong.
Okay. How about October 15th? Because it's a township case. We can do that.
Yeah.
All right, October 15th, 2025 at 9 o'clock a.m. Bond is continued.
Thank you.
Thank you. Ma'am, so you need to, I've put in this file that you will resume your substance testing after September 26th, okay? So ma'am, seriously hold on to the testing money so you can begin retesting, okay?
Yes, ma'am.
All right, thank you. I'll see you back here on October 7th. I'm
See
sorry,
you.
wrong day, October 15th. I'm sorry, October 15th.
I got it. I wrote it down.
All right, thank you. Take care, Ms. Gunn.
Thank you, Ms. Washington.
All right, the court will recall the matter of Javante Jackson. Case numbers 25 FB 1214 and 24 S 0300.
Tiffany Woods for the people.
Ashley Moten on behalf of Mr. Jackson.
Javante Jackson.
Thank you, Mr. Jackson. All right, your client wanted to speak to you for a minute. Where are we with that?
Yes, he did not want to extend this even longer or waste your time on Thursday. He will today be admitting to the jail cause. I do maintain that I hope in that Mr. Jackson can do better. We understand that he will be in custody until the sentencing. He would like to apologize to the court, and I am hoping for the best for Mr. Jackson.
Mr. Jackson, you think you can show me between now and the sentencing that you're gonna follow the court's orders, sir?
Yes, ma'am. Yes. It was just it's still some of my important things over there. I was just trying to get it. And that's all. I ain't know how else to do it. Cause like if y'all was gonna put me on the tether, I knew I needed a phone. My phone is with her, you know what I mean? But I don't want to be trying to have police go over there because of the kids and stuff. I just apologize to everybody for doing that. I was just trying to figure out how to be able to get my stuff up here. So, that's all I was doing. I knew I wasn't supposed to contact her. I apologize for it. It's just without having a phone, I knew I was gonna sit in here still, even after y'all sentenced me to the tether. So I know you need a phone to have in your property. You know what I mean? So, but yeah, I did. I was calling her, and I apologize. I ain't gonna call her no more.
Thank you, Mr. Jackson. All right, Ms. Woods, it looks like we don't have to have the Levi had set it for Thursday date. We can just move straight into sentencing. I will maintain him in custody. Until then, he can show me that he won't make that contact. But I'm going to ask you to reach out to her to ask if she does have his property, that she can turn it over so that he can have a phone and be able to be released. And I don't know if he has other property. I don't know if the two of you can talk, Ms. Moulton and Ms. Woods, to make arrangements for where that property can go to. I don't know if they'll accept all of that at the jail. I don't know. That's for the two of you to try to figure out. But I do appreciate that he was willing to come forward and be responsible and take responsibility for his actions. It says that we're taking steps forward with Mr. Jackson because Mr. Jackson had been one who would not be willing to make that step forward in the past. So it does show some maturation. The goal of the court and any court system is to have people change and to be better humans. Mr. Jackson, you've pled today to pouring a can of, well, maybe not the whole can, but at least pouring pop on someone and throwing a can at a female. That hopefully your acceptance of responsibility for that is a step towards trying to be better. And you will have classes. I hope that you take your classes and you take them seriously. It can help you to be a better person. I think you two have children together?
No, we lost the children.
Okay, all right. So, which says a lot too, you know?
Yeah.
Mhm.
You think you're fine after a car accident until this happens.
I'm gonna schedule, I'm sorry.
You had froze for like 5 seconds.
Oh, I was thinking. It wasn't,
Oh,
I
all
was
right.
frozen. I was thinking about what I wanted to say and if I wanted to say it yet. So I'm gonna see you back here on October 21st, okay? No
All
phone
right.
calls between now and then, okay?
Yeah, I got you, Ms. West.
We'll see you on October 21st at 10 o'clock a.m. The probation department will come out and talk to you and make a decision as to their recommendation, okay, for classes and the whole 9 yards. I think we still need to send us on the VOP. Anything you want to say regarding the violation of probation, sir?
Yeah, I accept I take accountability in what I did. You know, still
90,
stand on me apologizing about all of this. So
I understand. 93 days in the Washington County Jail, credit for 91 served. And this case is closed. All fines and costs waived.
was that for the violation of probation?
Yes, it is.
All right, all right.
So that case is now closed.
All right, thank you.
All right, thank you. All right, I'll see you all back here on October 21st.
Thank you.
Thank you. All right, do we have financial appears? Okay. Thank you. All right, the court will call the cases of Shemaya Alford, case numbers 20-00161 and 20-00160.
Tiffany Woods for the people.
Ashley Moten on behalf of Ms. Alford.
And Miss Alford
Um,
is not here. So she got arraigned by the magistrate on September 2nd and told to be present here today. And she has not shown up again. Bench warrant to issue in both matters. 25,000, 10% in each. Well, we'll call the matters of Mariah Donnell, case number is 20S 00501, 21W 001 738 B and C. We're here for show causes in each of these cases.
Tiffany Woods for the people.
Paul Barnett on behalf of the township.
Allison Muller here on behalf of Mariah Donnell. Your Honor, all the numbers we have from Ms. Donnell are out of service. Unfortunately, I haven't had any contact with her.
Defendant failed to appear at the last hearing as well. Bench warrants to issue in case number 20S 00501. 10,000, 10%. In case number, she hasn't made any payments. She's failed to appear and make any payments. Bench warrants to issue. 1 second. Then the other two matters, 3,500, 10%. Bench warrant to issue. Well, we'll call the case of Benjamin Hardaway, case number 12S 00771.
Tiffany Woods for the people.
Ashley Moulton on behalf of Mr. Hardaway. I did leave a voicemail. I have not been able to reach him.
Last I have is a report of September 19th and no payments have been made. Defendant has failed to appear. It's his first non-appearance on this matter. I will schedule it for a show cause on November 4th, 2025 at 10 o'clock a.m. Okay, I'll set it for a contempt hearing.
What was the date you set it for, Judge?
November 4th.
Thank you.
Oops. We'll call the matter of the state of Michigan versus Melody Monroe. Miss Melody Monroe made a $600 payment on today. I will schedule it, and she's current. I'll schedule it for September 23rd. September 23rd, 2025 at 10:00 a.m. for payment plan review. Roll call the matter of the state of Michigan versus Jerry L. Ward, case number 23S00083. Defendant made a $50 payment today. I made a $50 payment in August.
Your Honor, she's been current ever since you two have had that understanding with each other. I talked to her today. She said thank you, and she's going to continue to make those payments.
Thank you. All right, I'll schedule this for December 23rd, 2025 at 10 a.m. for payment plan review. I meant December. These are all December 23rd. Can't be today. December 23rd at 10:00 a.m. for payment plan reviews. And to my knowledge, that is all of our cases for today.
And I think we have one.
This is the on August 20.
C 3562. Please unmute and state your name, starting with the plaintiff, please, Mr. Collins.
My name is Stuart Collins.
Thank you. Please unmute Mr. Wykovitz and state your name. Please unmute Mr. Wykovitz. You're still not unmuted. Now, please state.
Michael Wykovich.
Wykovitz. Thank you, sir.
You're welcome.
All right. We're here today in this non-payment of rent case. This is the second hearing in this particular matter. Have the parties had a chance to talk? Where are we with this, Mr. Collins? I'll start with you.
Yeah, things haven't. Michael owes that much money in rent. I think he agrees with it, but he hasn't approached me to try to resolve it. So,
Mr. Wykovich, are you trying to resolve this with Mr. Collins? What are you trying to do today, sir?
Yeah, I want to resolve it. But I mean, the rent kept going up, like from $12.50 to $14.50 to $13.50, back down to $12.50, and I just couldn't keep up.
All right. Well, the reality today, is that he's entitled to a judgment against you, which would give you 10 days to move if you don't pay that, unless you work out something else with him. That's the way the law works. So do you
Okay.
try to talk to him and see if you can work out something different, or what do you want to do?
I just want to resolve it and move on.
All
I
right.
mean,
And if I resolve it.
I'm already moved out. I'm living in,
Oh,
I'm not even living there no more.
so Mr. Collins, he's saying he's moved out already. If he's moved
Yeah,
out,
he's moved out. That's true. But he still owes the rent. So that's what I'm concerned about.
well,
You
this,
know,
sir, this only entitles, let me see here. What do we have? One moment. All right, so you filed a claim for damages for judgment, money judgment, as well as a um possession judgment. So
right.
he's indicating, do you have your keys back already, Mr. Collins?
Yes, and he left the house in really good shape. I'm happy with that. And but in fact, the matter he owes the rent, and the fact that I was at different times I would go from 1250 to 1450 to 13. It's all very reasonable rent for what he was paying. So I don't think that's the issue. But he
Yes.
does owe that much money in rent. So
So I'm not arguing with you about how you moved your rent around. That's between the two of you and
right.
separate issue. What my question is today is, I'm gonna need to know from you the total amount of rent that you're owed, and you're not entitled to a possession judgment because you already have the possession. You're only entitled to a money judgment. So please tell me what your plus cost is.
$4,416 plus 130 in court costs, Your Honor.
For a total of $4,546. Is that correct, Mr.
Yes,
Collins?
that's correct. Thank you. Yes, Your Honor.
All right. So he's indicating he believes that you owe him an outstanding balance of $4,546 total, Mr. Wykovics. You're entitled to have a hearing on the amount that's owed. If you disagree with that number, are you in dispute over the number?
Yes, ma'am.
What's the dispute?
I did all the work on the house, and like I said, he kept jumping around with numbers, and I just couldn't keep up.
I understand you couldn't keep up, but I'm trying to find out what you're disputing about what he's saying that you owe. You say you disagree that you owe that amount. Is that correct?
Yes.
And what is it that you disagree with? What do you think? You're telling me that you did work on the house, but I don't understand what that has to do with anything. What does that mean?
I I think I should only have to pay half of that because of the way it kept bouncing around.
Well, he can change his rental amount. Is this a month?
Each month?
What is this? Is this a month-to-month lease?
No, there was no lease.
Well, that's a month-to-month, sir. So if you're in
He
a
did-
month, if you're in a
he-
month-to-month lease, then yes, he can change his rent.
Oh, I didn't know that.
Unless you have a lease agreement with him for like a year that says it's stuck at one number, he can change his numbers.
Okay. Then
So then
then
the
you
other
have to,
thing
huh?
you were talking about was something about doing work. Did you guys have some arrangements, Mr. Collins, regarding him doing work?
No, not really. I mean, the rent that I was charging him was under what was common, and I knew he was going to do some amount of work. But I mean, that's the reason I kept the rent down. But we didn't have any agreement that if you do this, I'd knock this much rent off. So I just that was one of the reasons I kept the rent at a reasonable price, because I knew he'd keep it up. So he did keep it up, but we didn't have any agreement. Okay, if you paint the wall, that is anything like that. That was never implied.
Mr. Wykovis, do you believe you had an agreement of any sort?
I had talked to him about painting and fixing stuff. I had when the other lady moved out. I had to fix holes in the wall, fix doors, all kinds of stuff, and he knew that.
Yeah, right. But we never talked about, okay, I'm going to take off some money rent, Mike. That was never discussed and never implied.
If you need full dentures but can't deal with the endless expensive
How long were you there, Mr. Wykovitz?
Huh?
2 years.
2 years. I had to think for a minute. Sorry.
No, you're fine. And so, was this a regular thing that he was doing work at your place, Mr. Collins, or was this just a couple of
No,
times?
it was a rental thing, and it did. There was, you know, the last tenants did leave it in bad shape, but you know, I had to move in, and you know, he's good at fixing things. He did a good job on fixing things up, and you know, but we never said, okay, I'm going to knock off 2 months rent. Whatever I did, you know, was already resolved, and you know, up until what I'm hearing right now, it never was a question of how much he owed on the rent. It was, you know, now he's bringing this up, but that was never brought up until now that I was supposed to deduct that work from 2 years ago off the rent. So,
Oh, this was work that was done 2 years ago?
It's been ongoing.
yeah, mostly. Well, he's kept up on the house. I'm not a handy person. He is. That's one of the reasons I had him come in there. I didn't want someone calling me for every little thing, and he was able to, you know, if something was broken, he could fix it. So that's one of the reasons I kept the rent low.
How many bedrooms is this facility, place, premise?
Three bedrooms and a bath, 1.5 baths, a nice yard, nice neighborhood.
So, Mr. Collins, raise your right hand to be sworn.
Oh, okay.
Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth? Sorry, I couldn't hear you.
Yeah, I do.
Thank you.
Yes, I do.
All right, so what months of rent are you claiming that he owes you for?
$4,416.
I know what the total is. I know what the total is. What months are you claiming that he owes you for?
We kept a running tally. You know, he would at the so it's not like you know, I would take off money based on the amount of time he worked here. So there was never any dispute about that figure there. So you know, he would work, and a few months ago he stopped working except for 1 day a week, and so that became a problem when he was only working 1 day a week. But every month it was like it started accumulating, and then he, you know, a couple of months ago he told me his boss was going to pay off the whole amount, and that never happened. Then he told me his boss's wife was going to pay off the whole amount. That never happened either.
I didn't hear a couple of things that you said. So I'm going to try this one more time. What you're saying that you didn't, do you have a ledger?
And I would let him work off hours, you know, for his rent. Then several months ago, you know, and the rent just kept accumulating. The rent amount due.
All right. So look, here's the problem. You just told me a few minutes ago you didn't have any agreement for him to work off his rent. Now you're telling me you do have an agreement for him to work off his rent.
Well, he worked at my pet shop. That's separate from what I had down there, I would give him credit for rent by working at my shop. So in other words, if he worked a day, I would take $120 off the rent, but that's separate from what he did at the house. I think he's trying to imply that because he did work at the house that I was going to reduce the rent. No, that was never agreement.
All right. So I don't really understand how his work at the pet shop should affect your ledger then. Do you have a ledger or don't you, sir?
Yes, I do. I mean, he doesn't dispute that amount. He never disputed that amount.
He did.
Well, I mean, he's bringing up that he thinks that the work that he did initially should have come off it. Well, that was 2 years ago, and it never was the issue.
Okay, but you don't get to decide whether it's an issue or not. I do.
Okay.
So having said that, where's the ledger that you just told me you have?
Well, I would keep track at I guess I don't have an official ledger. I have all the notes that I have. Every month I would keep a little notes. Mike owes this much's rent, and then he would pay cash, like $300 here, $200 here, and it was just little notes accumulated, and that's how I would do it. And Mike never. The last day we worked, he never said, "Oh, I don't owe that much." That was. He agreed that that was the amount, but he wouldn't sign anything for it. He said, "Yeah, I agree with that," but I said, "Well, are you willing to sign for it?" No, he wasn't willing to sign that he owed that much, but he did verbally agree to it.
Thank you. Mr. Wykovitz, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir. So tell me about your dispute. What is the dispute that you have?
The dispute I have is, I mean, a lot of it had to do with the house. I mean, the furnace needed work, the windows needed replaced, and he knew all this. The roof, he had some guy come out and fix, but then it started leaking again just before I moved out. And I mean, I kept the place up, I fixed everything, and I think I should be compensated.
And how much do you think you should be compensated for? I mean, you're asking me to knock off $2,270. Why would I do that?
Oh, I wasn't asking you to knock off that much.
You said half. That's half.
Well, at least 1,500. I mean, I do deserve that much.
Why? That's what I'm trying to ask you to tell me. Why do you deserve that much?
Because of all the work I did to the house. The drywall, I had to redo the bathroom. I had fix holes in the wall, put doors up, put trim in. And the place, the lady before that had dogs, and the floors smelled like, well, I can't really say it bad. And I had to replace the kitchen floor, the bathroom floor, and clean the living room floors big time.
You did all that?
Yes.
You supplied the materials?
No. Yeah. He supplied the material, but I did all the work.
You did the labor. And
Right.
is all that work you just outlined for me from over 2 years ago?
Was it?
No, it was not over
No.
2 years ago. It was when we moved in.
Well, it was when we moved in.
2 years ago.
Right.
Have you done any work since then?
No, because he wouldn't replace the windows, stuff like that.
Oh my gosh, Mike, come on.
All right. Thank you both.
Thank you, Your Honor.
Thank you, Your Honor.
All right, I'm gonna grant a money judgment in this case in the amount of $3,546.
I'm okay with that, Your Honor.
All right, thank you. You can prepare a judgment to that effect. Have a good day, everybody.
Thank you.
You too.
Well,
Bye-bye.
bye.
How do you go out of here?
We're gonna help you, Mr. Wykovitz, okay? The court will call the matter of Huron Heights and Huron Ridge versus Andre Thomas, case number 25C 3480.
Good afternoon, Your Honor. Brittany Brownlock on behalf of the plaintiff.
Good afternoon. Can I have that file back?
Andre Thomas.
Thank you. Good afternoon, everyone. We're here
Good
today
afternoon.
in hearing for non-payment of rent.
That is correct, Judge. I had an opportunity to speak with Mr. Thomas previously. To my understanding, he's agreeable to entering into a conditional dismissal. That agreement, we currently have current rent of due and outstanding of $150, other money due of $137, court costs of $163 for a balance of $450. That amount, as well as October rent, would be paid on or before October 10th, 2025. I did explain to him his rights and that the plaintiff would have a right to reinstate and enter a judgment in a writ without any further notice or hearing if that agreement is not followed through. He gave me permission to sign his name to that conditional dismissal, and I also have his email address so I can send him a copy when I file it with the court.
Thank you, Mr. Thomas. Is that a correct statement of the agreement that you reached, sir?
Yes, ma'am, that is correct.
All right. You understand you have a right to have a hearing as to the amount of rent that is owed. You agree with the final number of $450?
Oh, yeah, yep, the 450, yep, that's correct. And then the next month's rent
By
added
October.
on to that, but I got it. Yes, ma'am. I told her to the only thing is that my complex, I get paid every 2 weeks, right? So I knew when I've been back to court. This is my second time being for the same thing. Now, they took care of my last situation, which was cool. The last time I came to court, the fees, I only get paid every 2 weeks. So I told her the court fees is what I actually have to pay because I actually paid my rent. And then now all I needed to do was just put both of them together because I am back working, and to not get put out, I knew that I had to pay the next month's rent and the $450. I agreed to pay that. I just need a little time because I am paid every 2 weeks. So the time for the judgment of the 10th, I asked for that because maybe I'll get paid twice between then. Then I'll be able to pay the actual balance that I do owe. So yes, Your Honor, I did agree to everything.
Okay. Well, you'll have 3 business days from the date I signed this agreement to petition the court to set it aside for a good reason. And if you fail to make your payment by the 10/10 date, sir, they can come back in here and ask that I reinstate the case and issue an immediate writ of eviction against you. You do understand that part, correct?
Totally understand. Yes, ma'am. Yes, ma'am. I totally understand. But like I said, but if
The world's first titanium nonstick pan.
I understand. I
All right.
understand.
Have a great day. You're all set.
Thank you. So do I have any court date after this or just pay it
No,
before?
You need to pay it before then. If you don't pay it, they come back to me and ask to reinstate it. They're gonna do a conditional order of dismissal. She's gonna send you a copy of that because she got your email address. And you have 3 days from the date that you see that to say if she got something wrong in that document, okay?
Yes, ma'am.
All right, you're all set.
Thank you. Have a great day.
You too. Bye-bye.
Judge, real briefly, I noticed a Vicky Recaro on here. We dismissed that case yesterday afternoon.
All right, Ms. Vicky Vercaro, you may leave. You're Vicky Caro, or Caro. Your case has been dismissed. You're free to go. All right, the court will call the case of Huron Heights and Huron Ridge versus Janiston Frame, case number 25C 3476.
Brittany Brownlock on behalf of the plaintiff.
Hello, Your Honor. This is Janiston Frame, and great pronunciation of my name. Thank you so much.
Thank you. You're welcome. You can thank the magistrate because she wrote it out for me.
Thank you, magistrate, as well. Appreciate it. I go by Janet for short professionally. So
Okay, gotcha.
But-
Thank you. All right. All right, we're here in the second hearing for non-payment of rent. She did file a DC 539 form indicating she'd applied for assistance, so she's entitled to at least a week, but probably a 2-week adjournment just to see where we are at that time. Because actually that'd be that's the beginning of a new month, so a new month of rent would be added. Where are we with rent, by the way?
Rent, late fees, utilities, and court costs total $1,891.
I'm asking if possible, if it could be a 2-week adjournment, only because I have 2 different agencies that are really trying to work it out, and I'm very proactive with it. It could get squashed before, then, or I have a much better update, but I would really appreciate that. I am really getting this handled.
So on October 1st, a new month of rent will be due.
But I actually have an adjustment through MISTA, which would be very well because I had just started work. So it shouldn't be such a significant portion on my half that should be due on the 1st.
I see. Okay. Ms. Bromwich?
Judge, I'm not opposed to a 2-week adjournment. She did indicate her application is still pending with DHS, and she has a meeting with Catholic Charities tomorrow.
All right. Thank you. Then October 1st, 2025, and that's gonna be let's just do it at the same time, 1:30 p.m.
1:30. Okay, thank you.
Thank you. Have a good day.
You as well. Thank you all. Bye-bye.
One moment. Court will call the case of Beal Properties versus Andrew Miller, case number 25C3221. Nope, 3321.
Good afternoon, Your Honor. Dana Hall on behalf of the plaintiff.
Good afternoon.
Andrew Miller.
Thank you. Good afternoon, Mr. Miller. All right, we're here for this fourth hearing in this particular matter.
Yes, and Your Honor, I was able to speak with a representative from RPI in a breakout room. It looks like Mr. Miller moved, and this is my first time dealing with this case, so I had to go back through the timeline. He moved into this unit on April 4th. He had applied for a voucher with MISTA through RPI. It has not been fully approved still. There was a lot of back and forth between May, June with the manager needing to turn in paperwork, Mr. Miller needing to turn in paperwork. He was almost terminated for not turning it in. He turned it in, it had to be inspected. At this point, it sounds like all RPI needs is the lease from the property, and if they provide that before October 12th, then they will be able to pay. The voucher will be active, which is supposed to be for $682 out of the total rent of $1,053, but that will only go back to August 12th, which is when the approval began. So it's kind of complicated. So he still owes, he basically moved into the unit without his voucher being approved yet.
Oh, whoa. Excuse me?
But you go ahead.
I was already on the voucher when from the condemned buildings.
Yes, my understanding of this case is that this is one of the cases that came from Arbor One, and that he was transferred over from Arbor One to this new unit. So I'm not understanding.
Dude, what are you checking with the multimeter here?
I replaced my
he gets transferred because he's in a condemned building and it becomes his issue.
I do not know, Your Honor. I was trying to understand that from Miss Peterson, who's here. I did know that he moved. I didn't know until just now that he was on a voucher already.
Yes, I was on the voucher once I moved in there.
All right, so wait a minute,
Okay.
Mr. Miller. Ms. Peterson, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand. Thank you for showing today. Someone else showed last week.
Yeah,
So
my
please
sister.
tell me what's going on with this, because my understanding is that he was in Arbor One, he had a voucher, it got condemned, and they were required to move everyone out, and he got moved into a new unit. And so now tell me what it is, why this is the case where we are right now.
Sure. So there's a couple of things going on at once. Yes, he was on the program. Mishta, his unit was abated, actually, even before all the units were condemned.
What do you mean by abated?
Abated, they had to make repairs that they had not completed.
Yeah,
So
that's
abated
true.
is when they don't make the repairs at the re-inspection, then we hold back rent for up to 60 days and issue a voucher to move.
Okay.
So if they fix it, great, but they were condemned during that whole process anyway.
So it never got remediated.
No.
And then
They could be anything from a broken doorknob to something major. It's just bottom line is if they don't fix it by their due date.
Okay.
And that's our only remedy to obviously get landlords to fix things.
Gotcha.
So his voucher, he did have a voucher that was issued to him, and a moving voucher is what you would say, or in a landlord packet provided. It was sent to him on March 14th. It was effective for May 1st. In order for us to pay any landlord, of course, we need or approve a unit, we have to have the landlord packet filled out. It has to be approved, the rent amounts and everything, and be inspected. And then we can go forward to the later of the past inspection or the voucher start date. He was also going through an income change, adding a child to his home, which was going to increase the voucher. He was originally issued a 1-bedroom, but he was adding income and a child that was all happening at once. Do you want me to continue with the timeline?
Yes.
Okay. So he was headed to issue paperwork for that. During that time, he issued, we received a landlord packet on April 4th for the home at 630 Villa. And it was, he still only had the 1-bedroom voucher at that point because we hadn't added the child. And it was also, and that was denied on May 7th because the landlord failed to respond for corrections to the packet regarding water responsibilities. We got a new packet from them on May 29th.
So wait. When was it denied?
It was denied on May 7th.
So, let me I want to stop right there because now the packet was initially sent to him on March 1st.
March 14th.
March 14th. That's what you said. I wrote it down because you said something different. But then on May 1st, the landlord packet came back to you.
No.
What happened on May 1st?
May 1st is the official start date of his moving voucher. The contract for his old unit was not terminated until April 30th. So he got his voucher and his landlord packet prior to the contract termination so that he could, obtain housing somewhere else and hopefully not have a gap.
Right, and they had already moved me
Please stop
before.
talking. Please stop talking.
Okay, ma'am.
So on May 1st, you sent out a moving voucher.
No, we sent the moving voucher and the packet on March 14th so that by May 1st, it would be the soonest we would start a new contract and lease somewhere else.
All right. So what happens in a situation like this where he doesn't have a choice because he has to move, and you already know that because you have an abatement set up? So is he supposed to just stay in the condemned place? I'm not sure what's happening right now.
So it wasn't condemned at that point. There was an abatement for, I believe it was, what do we have? Pest control. His abatement is, hold on one moment, ma'am. I'm sorry. The abatement was right here. It was abated for needing an updated tag on the fire extinguisher, and upgrading the smoke detectors to the 10-year sealed battery. That was a HUD new standard versus the old smoke detectors that had the battery.
Right. You can stop with the abatement part.
Okay.
I'm talking about the fact that during the middle of the abatement, it gets condemned. So he obviously can't stay there.
Correct. So we were working with MSHA guided all of that. So again, we're the agent for MSHA. I'm not the authority. So we go by their policies. We didn't have the full on condemned must move everybody out at that time because he was already in a move. What they're supposed to do, I agree, is a difficult situation. I know the property was transferring people temporarily and then turning in landlord packets so that we could then approve it going forward, which it seems like that's what happened with Mr. Miller, that they sent him to a different unit that was not condemned on the property, and knowing they had to turn in the landlord packet and get the unit inspected before we would start paying. And they've done that for a few people there.
All right.
They moved him in prematurely.
So, but here's the problem. You can't claim something premature when the township or the city says you can't stay there any longer. They
Totally understand. And I believe we would have been able to go to MSHA to start it sooner, but they weren't even at that phase yet. They didn't even turn in a packet until May 7th. So they filled out the landlord paperwork and didn't even submit the landlord paperwork to us until May 7th.
Miller, when did you move? So you were trying to tell
I'm
me.
sorry, I was denied May 7th. My bad. Go ahead.
They ended up moving me. I want to say it was like March of 26, March of 27. That's when I ended up moving. I told the woman, I asked them about the RPI because, like I said, it's my first time ever being on RPI. So people was telling me like, hey, you got to put in the moving package or RPI going to end up saying something. That was the reason why I contacted RPI, and that's the reason why I put in the moving package. Then they sent it back telling me that the landlord side was not complete.
All right.
I ended up going to Arbor One.
Mr. Miller, please hold on. You're beyond our timeline so far.
Okay.
So March 26th, March 27th, they move him. You said nope, I'm talking to her now, not you.
Okay.
Okay. So on March 14th, you send the packet out, right? On March 26th, March 27th, he has to move because it's condemned. Are we on the same page? We
I'm
all
here. Yeah.
okay. So I guess my question is what happened between March 27th and May 1st?
If he was to lease up, we could go to the authority. Before that, and we had an approved packet with approved inspections and everything. We could go to the authority, since we're not paying rent on the old unit, to start a lease with the new unit in that situation. That didn't happen in his case, though.
Because
they did not submit the packet. They submitted a packet on April 4th. It was denied on May 7th because they would not return all the required items to move forward.
And when you say they, you're now talking about
landlord,
Bill Properties at this point.
Yes.
So Bill Properties did not send it to you until.
So they did not send the required corrections to the packet. So we had to deny it on May 7th. We gave them a lot of time to get it, but they didn't.
All right. That's where I want to stop again. So once it's denied, that means that you don't go back and pay for someone that's living in their unit?
It's not, it's a HUD and MSHA mandate. We cannot pay on a unit that does not have a contract or pass an inspection.
All right. And now I'm talking to Ms. Hull. Ms. Hull, when are you saying that his lease began at the 630 Villa Drive?
Just looking at the The ledger, I don't know if I have a copy of the lease, but the ledger begins April 1st.
All right. So we obviously have a problem from April 1st to May 7th already, because apparently that's your client's fault for not returning in the corrections timely, and it got denied.
That's what it looks like to me.
Okay. So now we're up to May 7th at that denial, and then what happens?
So when we deny the packet, we add time to the voucher if it ate up voucher time, and issue a new landlord packet and send a notice of decision to Mr. Miller that it was denied. We received a new packet between him and the landlord on May 29th.
Okay.
At that time, Mr. Miller was under a program termination regarding missing paperwork to add the child and wages. So we had to put that on hold until that process was complete. And it was also the process needed to increase his voucher so he could afford the new unit.
So missing paperwork about the child and the new income, you said?
Yes.
Okay.
That paperwork and everything was received after the program termination, but we were able to void it because we did get everything and we were able to enter it in June and get him at the end of June, get his voucher in good standing, and started the process again. And by the beginning of July, it looks like right after the holiday, July 4th holiday. The site followed up. We let them know that we needed, he was now in good standings.
Who followed up?
The property landlord asked us if we were able to proceed with him.
Okay.
We let her know that he's now returned to good standing. We did need, we put in a request for ownership, proof of ownership, the management agreement, proof taxes are current, and W-9 for the owner.
And when was that?
That was requested. I have a written request on July 18th. I cannot tell you, which I would be shocked if it didn't happen, but if there was a phone call at some point back then, because they were calling pretty regularly, but I can't confirm that. So,
all right.
it was put in writing. This is officially, we still need this.
All right.
Full coverage versus liability.
So from May 29th, when the new packet from the landlord and defendant was received, there was missing paperwork, and then you terminated him, but you reinstated it. Am I correct about that part?
Yes, he was issued a program termination for that. And so, but we were able to reinstate it. And when we got everything in June.
So when you reinstate it, once you get everything in June, does it pay for any rental amount?
No, because he's still not under contract and he still doesn't have a past inspection on the unit he's in. We can't do anything without a past inspection and all the paperwork approved. We can't go backwards on a non-contracted, non-inspected unit. That's a HUD rule and a administrative rule as well.
But none of this would have occurred but for the condemnation through Bill. Well, at the time it was Arbor One, but yes, right?
It would have, it looks like his unit still would have gone into abatement and we were terminating the contract regardless of the being condemned because they did have outstanding repairs.
But he's in a new unit now.
Now he's in a new unit and we still have not gotten the correct paperwork that would trigger the inspection so that we could have a lease and a contract going forward. Ideally, we would have received all this in March, maybe April 1st. Everything would have been done immediately. And we could have started a new lease May 1st, but that did not happen with this case.
Because of the condemnation.
No, that didn't happen because they didn't get the paperwork to us and respond with the initial packet in April.
Well,
Right.
which is part of because of the condemnation. If that wasn't happening, they would have done it in advance because people would know they were moving, but they didn't know they were moving until they were determined to be condemned.
No. That's two different, we have two different things happening here. He was already in abatement and going to move because of natural repairs.
Oh,
The
he was
condemnation is a separate, this would have happened no matter what.
okay, I
And
see.
so he got the packet about 45 days before its effective date, which we could have tried to approve it because we weren't paying on the old unit because it was abated, but it was contracted with Mr. Approval. But we couldn't get correct paperwork to do an inspection. So he was not left uncovered, like he was from contract ending to start date on the new unit because we didn't get what we needed from the landlord.
So what you're telling me is that whether it was condemned or not, this landlord would have been required to provide you with new information because his unit, he was required to move from that due to the abatement.
Right.
Oh, okay.
It's a standard move, basically, regardless of the condemnation. And we had to have all new paperwork, especially because of the new management change owner. There's nothing we could have done about that.
Gotcha. Okay. All right. And then now what, let me see where we are. I got to go back, read more of my notes because this is complicated. So on July 4th, they asked what was going on with the process, and you said that he was in good standing. And that's when you asked for all that owner information and all the rest of the documentation.
July 9th, and I do say we put that in writing to them, an email actually to them on the 18th, following up that we needed the proof of ownership, the management agreement, proof taxes are current, and W-9 for the management and ownership.
Okay.
Looks like we got that around the end of July. I think it was July 25th. Went to inspections, scheduled the inspection with the site for August 12th. And we left that day. We have said you're approved to execute a lease beginning today or later. And we still have not received the lease.
And that's supposed to be coming from
That would be the landlord. It could be from Mr. Miller or the landlord. So they need to send us the lease so we can have them sign the contract as long as the lease is, correct. And we would go back and start paying from the start of that lease, but no more than 60 days. HUD does not allow us to go beyond 60 days from the start of a lease to entering the contract for payment. So that's why I want that lease right away. So the faster we get it, entered, they get paid. They can have a lease starting August 12th.
So that is why Ms. Hall, she's saying it goes back to August 12th, which
They passed.
Yeah, it sounds like it looks like we got a problem with this case, Ms. Hall, for your client.
Yes, I mean, I think we could argue for June that that was the time period he didn't turn in his paperwork, but it's been like a long back and forth.
It
And
doesn't, but he got his went retroactive. It's yours that doesn't go retroactive. So if you had your paperwork in by the time he had his in, then it could have started from that time period. So technically you might be able to argue from May 29th until they got his paperwork. Let me see if I wrote that down. When did you actually receive his paperwork? I don't think I wrote that down.
From
the child and the new income.
Can I look at the file? Do you mind?
Of course.
I wasn't expecting that question, so
I understand. That's why I didn't write it down because you didn't get that date. So I appreciate that.
No problem. So yeah, the entering it was a matter of receiving it, verifying it. It's not just to be clear, not just receiving his paperwork, but being able to verify the validity of the paperwork and getting it entered. So I just want to make that.
So you don't have the date he actually turned it in then?
I'm trying to get that for you right. Okay. He's got another change going on right now, so we've got a couple of sets going here.
Okay, thank you.
Let's see.
Throw it as hard as you want. Go on.
Looks like He sent some things. He was kind of a little bit of a dragging out. Some things in April, some things in May. Then we got into final notice. It was May 5th. I'm sorry, I gotta keep
Okay,
going.
I understand.
And we had sent the program termination on May 28th. With an email. June 9th is when we got, well, let's see, one date stamp, June 9th for the citizenship declaration. It looks like we got everything about June 11th, so we voided his termination because he returned his paperwork, but the still had to be verified and entered. So turning it in late kind of delayed being able to verify what he turned in was correct, but he did turn it in. But we still couldn't move forward at that point because we had to increase his voucher, verify it so we could increase his voucher and income so he could afford the 2-bedroom townhome because he wasn't a 1-bedroom voucher, 1-bedroom unit.
So we're really talking, the new packet went out on May 29th and he's got his paperwork to you by June 11th.
The termination was sent out. And yeah, we got the new packet. Termination was sent out prior to that. We did get the new packet on the 29th and he was still in that. He turned his paperwork in June 10th and we were able to finally get it vetted and entered and increase the voucher. Looks like by the end of June. I'm looking for that date.
Right, but what I'm really looking for is what part was his delay, and we're looking from May 29th to June 11th, so we're only really talking 12 days.
Well, to be fair, he was given a request for documents so that he wouldn't go that long, then a final notice for documents so he would get it sooner, and then he was terminated. So
I understand that. I get all that. But what I'm talking about is this new packet. The landlord hadn't done their end. The new packet, therefore, didn't happen until May 29th. And then if he had submitted everything on that day, that's the day you would have started it. I mean, that's really the delay that he caused in the process. If it had earlier, it wouldn't have mattered because they didn't have their stuff in. Really, the delay is from the May 29th to the June 11th for him.
For him, yes, correct.
If I could just ask a question really quickly. So my understanding is once there's approval paperwork for this type of thing, like let's say it was completed on June 12th, would he get a subsidy for any of June or would it have to start July 1st?
There's still no subsidy without a contracted unit and a past inspection.
Well, I mean, assuming that all of that was done, assuming it all magically got done in mid-June, would it be able to start mid-June or would it have to start at the beginning of next month?
The day the unit passed inspection, yeah.
Oh,
if it was because his old contract absolutely ended on April 30th. No matter what, anytime after that, we would be able to start.
Okay, it doesn't have to start on the 1st.
No.
Okay, that's what I was wondering. Thank you.
All right. So I really appreciate you coming in and explain all of that because I have been confused for a long time about what's going on with this. And I understand why he couldn't explain it because if you try to make me re-explain it again, I'm not sure that I could, but I have some copious notes here so that if we have to continue to deal with this, we can. I think that what we need to do is is there anything we need to do to get the monies going other than the lease? So when Ms. Hull, when can your client get that lease over so that they can start paying August 14th at least?
I'm assuming definitely before Friday, I've been emailing them and they're responding as we're in court. So I would assume by Friday.
So having said that, hopefully by the time we come back, how long does it take once they get the lease over for the first monies to be issued?
If they turn in the lease and it's correct with the correct items listed in it, we'll send the HEP contract over that day, have them send it, if they can scan it right back to us and we can get it entered within 1 to 2 days. And then the payment, Mr. makes payment twice a month, so that they would know that.
So the payment won't happen until whatever the next
October 1st payment, check run with the state.
Okay.
And it'll go back to August 12th.
And when the October 1st payment happens, is it going to include October rent?
It'll include August, September, and October.
All right, thank you.
You're welcome.
All right, and so, then the next question is, what was the amount that he got, what? So is the approval amount is the same for this contract, correct? What would that amount be? Do you have that number?
I have it, Your Honor. The one from August 12th is that Mishta would pay $682 and tenant would pay $371.
You think you know David's.
All right, so it looks like we got some numbers to figure out, Ms. Hull, and
Yes.
Mr. Miller, it sounds like you are gonna owe some monies yourself. I don't
Yes,
know
I know that.
if you all want to go into a room and talk now, and then I give you a new date, or do you want to talk later? It's pretty complicated. What do you want to do, Ms. Hall?
I think if we come back, I need to get information from my client now that I have this timeline.
Yeah, and I think that unfortunately you might be stuck with this case because I don't want to have to try to re-explain this to someone else.
Yeah, that's fine. I am kind of new here, but I used to do all subsidy property, so I think I understand it a little bit better.
Okay, good. Well, it sounds like coming back around October 8th might be the best time for us to have it all under control and have the lease in, and we'll know exactly what number at least RPI should be sending out by then. We should know that number, right?
Oh, yeah, if we get the lease right now, everybody will know everything within that day. Are you asking me to be back October 8th?
That's up to Ms. Hall. Do you think you'll be her back then?
I do not know. I have a number I could call you. I think the number that I have is 313-846.
Whoa. I'm talking over so her number doesn't get
Oh, I'm sorry.
We're live going all over the country. So
Right.
can you take us off for one moment, please? Good morning, everyone. The 14B District Court is now in session. My name is Erane Washington, and I'm the judge that will be presiding over this session. Please make sure that your device is muted until your case is called. Once your case is called, then allow the attorneys to place their appearance on the record. Once they've placed their appearance on the record, then please unmute your device and state your name and turn on your screen. Turn on your screen, unmute your device, state your name. The court will call the case of Ypsilanti Township versus Adrian Harrison, case number 25T00269.
Paul Barnett on behalf of the township.
And good morning, Your Honor. Good to see you. Robert Ellman with and on behalf of Adrian Harrison. Adrian, can you please state your name for the record?
Adrian Harrison.
Thank you. Good morning.
Your Honor, we filed a couple of stipulated orders in this matter. I just thought, given the timeline, it'd be best to appear on the record. Mr. Harrison has a companion case, I guess, a felony case right now that we are working to resolve, pending him basically going into treatment and doing well. And I wanted to report that, he was released into treatment. He did inpatient at Spera and is now in transitional housing. So I'm hoping that we will soon be reaching a resolution in the felony matter, which.
If you don't want to freeze your hands off scraping ice off your windshield.
Help us reach a resolution in this matter. And so that all being said, I'd be asking for an adjournment.
No objection.
Thank you. It appears that he was arraigned on a bond violation for a new case, the 25T00271, way back in June, but I haven't seen him since then. And so I think that 25, no, that's not the new case. I guess the new case is the felony
The new
case.
case would be the felony, Your Honor, and without putting too much on the record, yes, the felony case as it relates would be an offshoot of this case.
I read the notes from the magistrate, so,
Okay.
yeah. All right, thank you. I think I fully understand now. All right, and you have no objection to the adjournment. How long of an adjournment are we talking about? When's his next court date in the felony?
If I could just have one moment, Your Honor, I don't have that date right in front of me, but I do believe it's a couple weeks out at least.
Do you know when your next court date is in your felony case, sir?
Well, no, I don't.
I'm pulling it up right now, Your Honor. I'm sorry. I should have had it here. And I'm not sure why they don't.
It has not been updated yet.
I don't see it online, Your Honor. I apologize.
All right, thank you. One moment.
So if it's the SB 1234, then it had a PCC on September 9th and it has not yet been updated.
Okay. All right, so we're still at the preliminary examination stage, apparently.
That's correct, Your Honor. We are hopeful that that felony matter will be resolved in a misdemeanor. So I'm hoping to keep it at the preliminary examination phase.
All right,
And so
October 20th.
that works for me, Your Honor.
October 20th, 2025 at 9:00 a.m. Bond will continue.
Thank you. Have a great day.
And it's for a pretrial and a bond violation.
Thank you, Your Honor.
Thank you.
We good to go?
October 20th, sir.
October 20th. Okay, I appreciate it. Thank you.
Thank you. Have a good day.
You too.
Ypsilanti Township versus Kaba Kandi, case number 25T00227.
Paul Barnett on behalf of the township.
Hey, good morning, Mayor. Police Court, Your Honor. Attorney Damian Caspi, number 85852 on behalf of Mr. Cavalcante. Mr. Conde, unmute and state your name for the record.
Good morning, Your Honor. My name is Cavalcante.
Good morning. We're here for.
Yes, good morning, Your Honor. We are here for a pretrial. Me and Mr. Conde have discussed the pending plea offer. At this time, if we can just set the final settlement conference.
Final settlement conference will be on October 31st at 9:30 a.m.
Thank you, Your Honor.
And then there will be a jury selection on November 7th. That is in person at 8:30 a.m.
Both at 8:30? Okay, thank you, Your Honor.
Well, the one is at 9:30, the first one, October 31st.
9:30, sorry about that.
And then the November 7th is at 8:30.
Thank you for that correction, Your Honor.
You're welcome. All right, we'll see you on October 31st, Mr. Conde, okay? Did you hear me?
Did you hear?
Yes, I did.
Thank you. Have a good day.
All right, thank
you. Log off.
Bye-bye. Ypsilanti Township versus Shantia Anthony Gill, case number 25T00390. We're here for a pretrial.
Paul Barnett on behalf of the township.
Ashley Moulton on behalf of Miss Gill, Anthony Gill. State your name, ma'am.
You think you're fine after a car accident until this happens.
Shantia Anthony Gill.
Thank you. Good morning, everyone.
Good morning.
Morning.
We would like to set this for a final settlement conference and an opportunity to address bond.
Final settlement conference will be October 31st, 2025 at 9:30 a.m. Jury selection will be November 7th, 2025 at 8:30 a.m. As to bond,
Oops, sorry, I was muted. It's Ms. Anthony Gill's understanding that the complaining witness is no longer at the home. It is her home with her name on the lease. She is requesting for the court to lift the no go to. She has no problem still complying with the no contact order.
Mr. Burnett?
Yeah, I didn't receive any confirmation of that, so I can't confirm or deny that. So I'm not in a position to stipulate to that condition. I can continue to reach out to the victim to ascertain if he has in fact moved from the residence.
Mhm. What, so are both names on the lease? Like, what is that situation?
Ms. Anthony Gill, his name is not on the lease, correct?
Correct.
Just yours.
And my kids, yes.
How many children do you have, ma'am?
I have 5. My youngest is almost 5 months.
And all 5 of you are out of the home?
No, they're currently with him because they have to still go to school, and he sits with the younger one. So I'm not there because the other judge told me that I couldn't go back to my house.
All right, now I'm confused. They sit there with him where?
At my house.
But you just said that he was no longer there. Well, your attorney represented that.
That's what I told her last time when I talked to her a couple of days ago. I said they're with him. Like, I'm not there, but they're with him.
So they're not, you said he moved to Ohio or something, so he's no longer in Ohio?
No, I said that's what he said he was going to do. Like, he was moving to Ohio.
So he is still in the home?
From my understanding, that's what I heard, like, before.
Okay.
Yeah.
My apologies, Judge. So Miss Anthony Gill, if he is in the home, then you both can't be there.
Okay, but how will this whole situation work out then? Because I need a place to stay. I can't just keep going to everybody's house.
I think the 2 attorneys should talk and figure out if there's some type of consensual contact, if he wants that or not. And we address this once we have more information. Because at this point in time, the bond motion is denied. She can't go back there if he's there. Unless he's spoken to the prosecutor and they've agreed to some other arrangement.
Okay, thank you.
You're welcome. All right, ma'am, you need to continue to speak with your attorney who will hopefully speak with the prosecutor and maybe they can work something out, but you can't go there unless something is worked out. Okay?
Okay.
All right. Thank you.
Thank you.
The court will call the matters of Olivia Jones, 25S00093 and 24S00195.
Tiffany Woods for the people.
Good morning, Your Honor. Good morning, everybody. This is Matthew Mansour, Assistant Public Defender, on behalf of Miss Olivia Jones. Olivia, can you please say your name?
Olivia Jones.
Thank you. All right, we're here today for a review and a violation of probation.
Yeah, Your Honor. We're really just looking for an update on restorative justice here. The probation violation is the new case that's set for the restorative justice. And the paperwork is filed. I've spoken with Olivia and her mother, and I think they're just waiting on a date right now. And if Miss Woods can confirm for me.
Judge, I don't have any information, unfortunately, on restorative justice, so at this point, defense counsel knows more than I do.
If you're an American living legally in our 50 states, you are
So we're just waiting for a date. Why don't we put it over for, let's go with 60 days, November 17th. At 9 a.m. Ms. Woods, hopefully you'll have an update at that time. Fine.
Thanks, Your Honor. Thanks, everybody.
Thank you.
You're welcome. See you then, man. Well, we'll call the case of the State of Michigan versus Brandon Samples, case number 25S00389.
Hey, what's for the people?
Good morning, Your Honor. Edward Drugas for Brandon Samples.
Good morning, Brandon Samples here.
Brandon, could you show your, there you go.
Oh, yeah.
Thank you. All right. We're here for a pretrial today.
Correct, Your Honor. I was able to receive all the discovery, including video. At this time, I'd like to set this for a final settlement conference date.
And I just want defense counsel to know that the plea offer is plead guilty as charged with HIDA, restitution, and probation. Once it's set for final settlement conference, that plea offer is off the table.
Brandon, I went over that with you. Is that something that you want to discuss a little further, or are you ready to set this for a settlement conference?
Yeah, HIDA is cool. Yep.
All right, well, with that, Your Honor, if we could adjourn this out, I know the next settlement conference date's not till the end of next month. If we could set up for another pretrial.
September 29th, 2025 at 9 a.m. Bond is continued, so you can further discuss the HIDA.
Thank you, Your Honor.
Thank you.
Thank you.
You're welcome.
Bye-bye.
Bye-bye. The court will call the case of Jermaine Mangum, case number 25T00221.
Paul Barnett on behalf of the township.
Ashley Moulton on behalf of Mr. Mangum. State your name, sir.
Jermaine Mangum.
Sir, please turn on your screen. Sir, please turn on your screen. Thank you. We're here for a pretrial today, and it looks like he was arraigned on a bond violation.
If I may have a moment on the bond violation, but we will be requesting to set this for a final settlement conference.
Bond violation is from August 31st, 2025. He looks like he went to the residence that he was not supposed to be at on Woodland Hills Drive. Is the allegation?
Okay, I'm sorry. I did not see that. Is it possible that we could go on the breakout room to discuss?
Yes, well, I'll pass it.
Thank you.
The world's first titanium nonstick pan.
Case numbers 24S00257, and then there's a show cause for a Township 21W00065B. The first matter is a pretrial.
Tiffany Woods for the people.
Paul Barnett on behalf of the township.
Allison Muller here on behalf of Mr. Frederick. Mr. Frederick, can you please state your name?
Yeah, Frederick.
Thank you.
Your Honor. Oh, I'm sorry.
Go ahead.
Your Honor, for the pre-trials, I know we've been adjourning these out for quite some time. We are still tracking the felony cases. The offer again here, I believe, from Ms. Woods is to dismiss once he's entered into his felony pleas. That has not happened yet. Currently, I believe all of his circuit court pre-trials are scheduled for October 7th. So we would be requesting an adjournment for past that date. We'd have no objection, Judge.
Pre-trials adjourned to October 20th, 2025 at 9 a.m. Bond is continued with release to treatment if he sees fit or they see fit.
Thank you.
We'll see you on October 20th, Mr. Frederick, okay?
Thank you.
Thank you. Have a good day, sir.
You too.
Bye-bye. We'll call the case of the state of Michigan versus Peter Paloma, case number 25S00362.
What's for people?
Matthew Mansour on behalf of Mr. Paloma. Peter, can you please state your name?
Peter Paloma.
Thank you. All right, we're here for a trial today.
Yes, we are, Your Honor. I believe Mr. Paloma and Ms. Moten had a conversation prior to this pretrial. Mr. Paloma would like to set this matter for final settlement conference.
I just want defense counsel to know that we were trying to contact the victim to see if they're interested in the restorative justice program. We're just waiting to hear back. I don't know if that's anything that the defendant would be interested in doing. But once it's set for final settlement conference, there will be no more restorative justice.
Understood. Thank you. Mr. Paloma, do you know what the restorative justice program is? Do you have questions?
No, I do not know what the program is. And I do have questions.
Okay.
Do you want me to say it?
Listen, you want to go into a breakout room? Or you want him to wait for Miss
Your Honor, I have Mr. Jones, D'Angelo Jones, and then I could go in a breakout room or whatever you want to do.
Then I'll pass it and we'll see who comes back first.
Okay.
Thank you. The court will call the matter of the State of Michigan versus D'Angelo Jones, 24S00283.
What's for people?
Matthew Mansour on behalf of Mr. D'Angelo Jones. D'Angelo, can you please say your name and turn on your camera?
Angelo.
Your
Yeah.
your connection is really poor, so I couldn't make out anything you said. We're gonna turn your camera off and see if that helps, okay? Right, can you say your name? Mr. Jones, can you say your name
D'Angelo
again?
Jones.
Thank you. All
D'Angelo Jones.
right, thank you. We're gonna mute you now because you have the baby, which is pretty loud in the back.
Okay.
All right. We're here for a pretrial.
Oops. We are, Your Honor. We do have a resolution. Whenever you're ready, it's just that he's going to be taking advantage of the DV4A statute.
Thank you. All right, Mr. Jones, it's my understanding, sir, that you're going to be pleading guilty as charged to a charge of domestic violence. Domestic violence is a misdemeanor. It carries a maximum penalty of up to 93 days and or a $500 fine plus court costs. In exchange for that particular plea, you're going to receive the opportunity to be placed under the 769.4A, which is a statute that allows this to be erased off your record if you complete all the terms of your probation, so you wouldn't have a history of domestic violence would not be on your record. Is that your understanding of the agreement? You'll have to unmute yourself to answer me.
Yes.
And is that what you want to do?
Yes.
All right. Please raise your right hand to be sworn. I'm going to turn on your camera for a short period of time so I can, I'm going to ask you to turn on your camera so I can see your hand raised. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
I'm gonna turn your camera back off. All right. I'm gonna go with some rights that you have that you're gonna be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again, okay?
Okay.
You have the right to have a trial by a jury or a judge, at which time you can call witnesses to speak for you. You can get an order signed by this court to require that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and you have the right to be a witness for yourself. Or you could choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that.
If you need full dentures but can't deal with the endless expensive dentist
to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes, I understand.
You understand you're going to be giving them all up and you're not going to be having a trial of any sort?
Yes,
You also understand that there's no automatic right to appeal this decision. So the decision that you're making today, in all likelihood, is going to stick with you.
yes, I understand.
And if you're not a US citizen, sir, you could have immigration consequences. Do you understand that?
Yes, I understand.
And if you were on probation, parole, or bond on August 5th, 2025, when the 2024, when this happened, then you could be in violation of that probation, parole, or bond if you're still on one. Were you on one on in August of 24?
No, I was not.
Okay. And if you are not, I think that's all I was actually supposed to tell you. To the charge of domestic violence, how do you plead?
Guilty.
Has anyone promised you anything other than what we put on the record to get you to plead guilty?
No,
Anyone threaten you in any way, shape, or form?
no.
All right. On August 5th of 2024, were you at the vicinity of 2695 International Drive here in Ypsilanti Township?
Yes, I was.
And while you were there, was there a Kimberly Jenkins present?
Yes,
And what's her relationship to you?
we were dating, it was like on and off.
You were dating, okay. And so, on that particular date, did you assault and or batter her in some way?
I grabbed her up and she pushed off and ran away and called the cop, and I got arrested.
Okay, so you grabbed her up, you grabbed her in her collar, and she didn't like that, huh?
She didn't like it at all. No.
Okay, all right. I find that there's a factual basis for the plea and has been willingly and knowingly made. Are you satisfied, Ms. Woods?
Yes, Judge.
Defense is satisfied, Your Honor. Thank you.
All right. Sentencing in this matter will be on October 20th, 2025 at 10 o'clock a.m. So you're gonna need to make and keep an appointment with the probation department.
Okay, I can do that.
I'm gonna give you their phone number. Anybody else on the call should write down the phone number at this time too. Let me know when you have a pen.
I think he gave it to me. I wrote it down on my phone.
Oh, Mr. Messer, you gave it to him? Okay, all right. Please call them tomorrow after 9 o'clock and they'll schedule a time for you to have a probation interview, okay?
Okay.
You're all set, sir. Have a good day.
Okay, thank you.
Bye-bye.
And Your Honor, I could go with Mr. Palama if you.
Okay, we'll put you in with Mr. Paloma, and I believe that we're gonna be in a brief recess. We're gonna see if we can get Mr. Amadeus. Okay, Mr. Amadeo, we have to wait for the jail to bring your individual in. And apparently
Judge.
there's someone else already, so we'll ask them to bring your person next, okay?
Thank you, Judge.
Thank you.
Dude, what are you checking with the multimeter here?
Mhm.
And Mr. Mankham will admit to the violation and request an opportunity for an explanation.
Mr. Mangham, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand. Mr. Mangham, you are aware that you have a right to have a hearing on this violation, but you're gonna waive that right and you're gonna admit to the violation, is that correct?
Yes.
Mhm. So you went to the location on Woodland Hills, sir?
Yeah, I went to the, yes.
I find that there's no willing admission to the violation. Are you satisfied, Mr. Barnett?
Yes, Your Honor, thank you.
Ms. Moulton?
Yes.
All right. What is the explanation, Ms. Moulton?
Originally, when Mr. Mankham was arraigned, the complaining witness wasn't living there. It was over a month at that point that she lived there. And he did not know where she was staying at that time. And he was told to not go to her home. Oh no, you've been living. I'm sorry. Yeah, he didn't know where she was living at. He was told not to go to her home, not to go to her work, and he complied with that. I did verify with the ROA. It just says not to go to her home or her place of work. He was not told to not go to the Woodland Hills address, which is his home, where his name is on the lease. And then later, he was picked up on the violation. I'm not sure if they spoke to the complaining witness and then she went back or whatever the case may be. Once he got arraigned the second time, he received a personal bond because the magistrate confirmed that he was not told to not go to that specific address. Since then, he hasn't had any issues. The third party contact, which is his grandmother, has been working well. And he hasn't been back. He's been living with his mother since then.
Thank you. Anything from the township?
I mean, as long as he understands he's not to go to that address, it sounds like he's aware of that now. I'll leave anything else to Your Honor.
And she's right. That is all that it says on the order. Do not go to her home or work. It doesn't say that specific address. I'll accept that. All right. As for the pretrial,
We're requesting a final settlement conference, please.
I think you did say that early on. Final settlement conference will be on October 31st, 2025 at 9:30 a.m. And jury selection is going to be on November 7th, 2025 at 8:30 a.m. Bond will continue.
Thank you.
You're welcome. We'll see you on October 31st. That's on Zoom again, okay, sir?
All
The next one on November 7th, if we get to that point, is in person, okay?
right.
Thank you, sir. Have a good day.
You too.
The court will call the matters of Sherry Walker, 23S00762, 25S00254, 17FB 1798, and 19S00071.
What's for the people?
Brunel on behalf of Ms. Walker in the matter ending in 254. Good morning, Judge.
Good morning, Mr. Burdell.
Good morning.
Good
morning.
morning.
Please
Ashley
state
Moulton on
your
behalf
name.
of Ms. Walker.
Oh, sorry.
And Your Honor, we are here for pretrial. As matter 254, I was going to ask to approach.
All right, we can approach them all. Good morning, Ms. Walker. Can you state your name? I think we talked.
Yes,
about
ma'am. Sherry Walker.
Thank you. We'll see you. We're gonna have.
Okay. Okay. Yep.
Throw it as hard as you want. Go on. Watching it zip away feels like it.
Yes, again.
Okay. Okay. All right.
Thank you. Is Mr. Mansour back with Mr.? All right, the court will recall the case of the state of Michigan versus Peter Paloma, case number 25S00362.
Tiffany Woods from people.
Matthew answer on behalf of Mr. Paloma. Peter, can you please state your name again?
Peter Paloma.
Thank you.
Your Honor, thank you for that opportunity. Sorry to cut you off. He is interested in restorative justice, so we would not like to set for final settlement conference. We'd like whatever adjournment we can get, and then to see if restorative justice is an option.
October 20th? Well, actually, you're just still trying to reach out to the, I'm gonna set this sooner. September 29th, 2025 at 9:00 a.m. And so at this point, we're just waiting for the complaining witness to confirm restorative justice.
That is correct, Judge.
Fine, we'll continue. We'll see you back on that date, sir, and we'll know by that time whether or not it's a genuine option. Okay, Mr. Paloma?
No problem. Thank you.
Thank you. Have a good day.
You too as well. Thank you.
Thanks, Your Honor. Sorry to cut you off again.
No, that wasn't intentional. I only get upset when people do it intentionally.
I know. Oh, I know.
Thank you.
Yeah.
Do we know who the Motorola G5 is? Okay. All right, I don't think we have anything else that's ready to go just yet. Mr. Chandler, You're waiting for your attorney to show up, so maybe you want to call your attorney and see where they are. Court will be in a brief recess. Mr. Jones, none of your clients are here, so maybe you should call them to find out where they are.
Does your garage get cold?
All right, the 14B District Court is back in session. The court will recall all of the Sherry Walker matters.
Good evening, what's for the people?
Kyle Burrell on case number 254 on behalf of Sherry Walker.
Ashley Moulton on behalf of Ms. Walker. On the other three cases, state your name, ma'am.
You're muted.
Oh, sorry.
Please.
Hello.
Hi,
Hi.
please,
Oh, okay.
please state your name again.
Jerry Walker.
Thank you. All right, you had a chance to speak to Ms. Walker. I'll start with you, Mr. Burdell. Where are we?
Your Honor, thank you. At this time, I did speak to Ms. Walker. At this time, we are going to ask for an adjournment. It's my understanding that that Ms. Moulton is going to set her case for final settlement conference. Our case is kind of dependent upon what happens at that date. So I would ask that the pretrial be set for the same date as the final settlement conference. I understand that it may be a little bit of a way out.
All right, pretrial will be October 31st, 2025 at
Is that
9.
Halloween? Is that Halloween?
It is Halloween.
Yes, Ms. Walker.
No, just wait. Halloween is not a good day.
It'll be fine.
Okay.
Not like it's Friday the 13th.
Okay, right.
All right, that'll be at 9:30 a.m. And
Understood.
bond will continue. That's in case number 25S00254.
Thank you, Judge.
And then in case number 23S762, the child abuse charge, that one will be set for final settlement conference on that same day. Is that your request, Ms. Moulton?
Yes, please.
Final settlement conference, October 31st, 2025 at 9:30 a.m. with jury selection on November 7th, 2025 at 8:30 a.m. Bond will continue and so will the reviews. They will all go to that same date as well. And by that same date, I mean October 31st at 9:30 a.m. We'll see you then, ma'am, okay?
Okay, thank you so much. Is that it?
That is it.
Okay, thank you.
Thank you. Have a good day.
You too.
Thank you, Judge.
You're welcome. Bye, Mr. Burdell.
Judge, can I have a moment to reset my computer? And I do have a ticket in for Wednesday, so.
Yes, you may.
Thank you, Judge.
Since May, like he was supposed to be. Mr. Brown, it still remains your responsibility to ensure that your tests get to where they need to be, your test results, okay?
Yes, ma'am. Of
All right.
course, I'm on it.
All right, thank you. So at this point, we will withdraw the bond violation.
Thank you. When I get a hold of Mr. Black, I'll sign back in. I'm bouncing around, as you know.
All right, but we still need to address the pretrial.
Unfortunately, I'm gonna need a little bit more time. I really thought we were only gonna deal with the VAP today. And I apologize for that. Can we come back in a couple, 3 weeks?
How about September 29th? Are you available then?
Let me take a look real quick. I can't imagine it's not a good day, but let me look real quick. So 9:29. Yeah, that's great. What time do you want us in?
9 a.m.
All right, perfect. I'll see you. Well, hopefully I'll see you again this morning, but I'll see you on the 9 a.m. on the 29th. For
All right, thank you.
It's just,
You're welcome.
you've always made me feel special with all the scheduling. Thanks.
You're welcome. Your bond is
I can't, Judge, I'm sorry, I can't keep a straight face, but I respect,
I appreciate that.
Thanks.
Mr. Brown,
I'll see you in a few minutes.
see you in a few minutes. Your bond
Bye.
is continued
Bye-bye.
and you're out, sir. We'll see you back here on September 29th, okay?
Thank you, Your Honor.
Okay, thank you. The court will call the case of the State of Michigan versus James Chandler, case number 25 FB 1169. We're here for a pretrial.
Good morning, Your Honor.
Oh, Ms. Woods is not back yet. I'm sorry, Wait, we gotta wait for so the state prosecutor had to sign out briefly and we're waiting for her to sign back in. As soon as she signs back in, we can get started again.
Stop using
All right, Miss Woods, we called the James Chandler matter.
Tiffany Woods for the people.
Yes, Your Honor. Brandon Bird on behalf of James Chandler. Mr. Chandler, can you please state your full name for the record? You have to unmute yourself.
Okay. Can you hear me now?
Yes.
Okay. James Willard Chandler Jr.
Thank you. We're here for a pretrial today.
Respectfully, Your Honor, we'd like to set this matter for a final settlement conference.
And defense counsel, the plea offer would be to plead to count 2, DV first, and we would agree to dismiss count 1. There would be no upfront jail and a referral to probation. Once it gets set to final settlement conference, that plea offer is off the table. Thank you.
All right, thank you.
Do you need time to discuss that with your client, or have you already discussed it?
I could discuss it. You said when we get to final settlement conference, it's off the table, correct?
If it gets set for a final settlement conference, it's off the table.
Oh, then we'd like to set this matter for a final settlement conference, Your Honor.
All right, so you're gonna not discuss it with him? He understands it all, and so you're taking it off the table at this time?
No, my client was adamant about going to trial, but I could go in the breakout room and discuss it with him, Your Honor.
All right, it sounds like he's shaking his head. So you don't want any offers, is that what you're saying?
No, ma'am.
All right, so I guess you don't need to discuss it with him. So she was gonna reduce it to a DV first, and you're rejecting that offer, Mr. Chandler, is that correct?
Yes.
All right, then I will schedule this for October 31st. (2025) at 9:30 a.m. for final settlement conference. And jury selection will be on November 7th, 2025 at 8:30 a.m.
Thank you, Your Honor.
You're welcome. Your bond is continued, sir. We'll see you on October 31st at 9:30 a.m. for final settlement conference. That's on Zoom. The next one, you too. The next one is in person, so please plan for that in the event it goes that far, okay?
Yes.
All right.
You and your honorable court have a great day, Your Honor.
Thank you. You too. Take care.
Thank you.
Hey, call me. Call me. How do I get out of here?
We'll help you out. Is Mr. Diego Rondon, is that Mr. Amadeus?
It is, that's the one that I just talked up top. Yeah, we don't say we got though because the labels went out.
Okay, thank you.
Can you see if it's stamped?
It is stamped.
Okay, so I'll need to throw your copy.
Okay. Oh, thank you. Is Timothy here?
No, I just let him in.
Oh.
He just came in.
Okay.
Hello,
Good morning.
thanks for calling. Good morning. Thank you for calling. I'm ready to assist.
Please raise your right hand.
Lead interpreter. I appreciate that, but he
That's it for today, ladies and gentlemen. I broadcast every day at 3 o'clock p.m. Central Time, 4 o'clock Eastern Time. So you all have a wonderful evening. Ta-ta and ciao-ciao. I will see you again soon.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's over.